All right, there we go. We have attendees coming in. Awesome. All right, awesome. So we have 12 people on. I'm just gonna ask real quickly our wonderful panelists to stop your video until it's time to present.
Okay.
So I'm gonna do that here and here. Okay. All right, we're gonna give it another 2 minutes, but for the people that are on now, thank you for coming. We're gonna start in just a little bit. All right, so I think we're good to go. I'm gonna go ahead and start here, I think. Yeah, we have 16 people. All right, great. Okay, so everyone, welcome to the second ever NJ Thrives Thursdays. Super excited today. Wonderful guest speaker we have on. And yeah, let's get right into it. So your host, myself, NJSBDC consultant, but our main focus for today's event with Mike Maliar, intellectual property and business attorney. So today's going to be packed with a lot of value for you guys. But first, before we get into that, I want to go through a quick agenda. We're going to go through some headlines, then we go straight into the webinar and some Q&A. Before that, just keep in mind 3 little things. We're going to have a survey at the end of this event. It's a quick 3-minute survey. Would really help if you guys stick around and fill that out for us. Will help us improve future events. Remember, you're going to be able to access this webinar within 48 hours on demand on our site, and I'm going to put, and you're going to get a link for that in an email. So make sure to watch for that. And yeah, let's go ahead and get started. So headline for today. So the SBA 2001 grants update. So they released a $5 billion program, and they have some new information as to who qualifies. So if we scroll down on this article, it's by NJ.com here. And this is the main point of this article, that to be eligible, small businesses must have no more than 10 employees, be located in low-income areas, and have had an economic loss due to the pandemic of greater than 15% over an 8-week period since March 2nd of 2020, so last year. So the links to this, I'm actually going to drop that into the chat so you guys have this available. And you can make sure that you're taking advantage of all the funding opportunities that the SBA is doing for people affected by the pandemic. But that's the headline. Now we're going to get into the webinar. So without further ado, would love for Mike to turn on his camera, and I'm going to stop sharing my screen, and we can get the show rolling.
Yep, I lost it right there. I'm
There you
going
go.
to share this. Here we go. Okay, are you all seeing the, oops.
Beautiful. Yep.
Okay, perfect. So, hi everyone, my name is Mike Naliar. Today we're going to be talking about intellectual property for small businesses and ways you can use intellectual property or IP, and ways to protect yourself from others as well. So the overview of our presentation is I'll show you my background. Then we're going to go right into just a general background of IP and the ways to protect it, the various forms of IP protection. Then we're going to get into some practical tips and considerations for IP for your business. And we're also going to talk about how to identify your IP and how to protect it. So this is me. I am an attorney. I practice in intellectual property. I am a patent attorney as well, so I passed the patent bar. And I do contract work, contract drafting, negotiation review, and work like that. I went to law school at Seton Hall in Newark, so I'm somewhat local. And before that, I earned a degree in chemical or biochemical engineering from Rutgers down in New Brunswick. So I'm pretty local. Okay, so legal disclaimer, this is very important. This I'm going to read to you. I am an attorney, but I'm not your attorney. Nothing contained in this webinar is intended to form an attorney-client relationship. The information provided during this program is general in nature and is not legal advice. It's also subject to change because the law is ever changing. And if you have any questions or concerns or need any legal help, you should seek the advice of competent legal counsel of your choosing before acting upon any of the information that is provided in this program. Not only because it may have changed, but it may also not be very relevant to your particular situation. So topic 1. IP, we just mentioned this. We're going to go through this pretty quickly just so we can get to the good stuff towards the end. So what is IP? IP is a very broad definition. It's ideas, knowledge, and basically any creation of the mind. So innovations or inventions, those are protected by patents. Proprietary and sometimes confidential information that you can protect with trade secret. Your company's brand recognition, goodwill, or reputation in the market, that's protected by trademarks, and any creative expressions that you have. So works of art or books or marketing materials even, that can be protected by copyright.
Quick question, how about a recipe?
A recipe. So we're going to get to that. And
Awesome.
it's a little bit of both. So the recipe itself can be protected by a patent if it's new and non-obvious and meets certain other criteria, which we'll get to.
Okay.
But for the most part, it's protected by copyright. And we'll discuss why.
Okay.
So here's what we're going to discuss with patents. We're going to go through this pretty quickly because right now in this current climate, patents are not as desirable as they used to be, mainly because they're very, very expensive. But it's still important to know about them so you don't step on somebody else's toes. So the basics. In order for an invention to be patentable, it has to be useful, which is a pretty easy bar to meet. And it needs to be new and non-obvious over what's known as the prior art, which is basically everything that's come before. So if it's been done before, it's either not new or non-obvious over that art. And this has to apply to at least one element of your invention. Now, I say element because a patent is made up of several different sections. One of the most important of these is what's known as the claims. This is the section at the very end of a patent, which has those weird archaic sentences that sort of read like a property deed outlining exactly what your property consists of. And essentially that's a great analogy to what a patent claim is. And in the patent claims, you list out the elements of your invention. It could be A, B, C, D, E, F, whatever those elements are, and that's your invention. And that claim is what you can protect or what others can protect with their patents, and not what's written in the body of the patent, which is known as the specification. Now, the general process for getting a patent is you file a patent application. It's examined by the US Patent and Trademark Office, which I will abbreviate as USPTO from now on. If it passes examination, then it issues into a patent. Now, it's very important to note that only issued patents give you the patent right, which is to stop others from making and using your invention. Patent applications do not. So you may have heard of provisional patent applications. They're not the same as like a normal non-provisional, and they also don't provide patent protection. They're just basically a placeholder for you so that it stops the prior art from accumulating. So the patent right. This is, again, also very important. And one of the things that the vast majority of people, even other lawyers, don't quite get about patents is that it's a negative right. And what that means is it doesn't allow you to use what you've invented. You could have a patent on something and still not be able to actually make, use, or sell your invention. What it does is it lets you stop others from making, using, selling your invention. And that's a very strong right. Now, we're going to jump right into infringement. So for a patent to be infringed, every single element, which I mentioned in the previous slide, of a patent's claim or claims must be found in the allegedly infringing, using some legalese there, but it must be found in the product or process that you're using. If you are missing just one element, that's enough for there to be no infringement. Now, that's important because, as I mentioned earlier, for an invention to be patentable, you only need one element to be new and non-obvious over the prior art. So the key takeaway and what you should really understand about this is that you can have a patent and still infringe somebody else's patent by trying to make your invention. And this means that they're just separate concerns and they require different analyses. So how's this work? Here's an example. I'm not going to spend too much time on this because we really want to get to the good stuff. But here's a basic hypothetical where there are 3 inventors. They all invent a different type of soup, and they're all recipes. So they've never been done before. And they all go to the patent office in the order that, they're listed: inventor 1, inventor 2, inventor 3. And down below are the situations and what happens. All right, so what do you really need to know about patents? Like I mentioned not that long ago, you can infringe others even while having your own patent. That needs to be hammered into your head, that just because you have a patent doesn't mean you're protected and you're safe. Which means also that avoiding infringing other patents, like other companies' patents or what have you, is often more important than actually having a patent yourself. Because if you can't sell your product, then do you really need a patent on it? And there are some reasons you may want to license it. There are considerations involved, but for the most part, if you're still going to infringe somebody, then why spend the time and money, getting a patent? And also, when considering patents, and also we'll get into this a little bit in trademarks too, but you should be cognizant of your business's commercial context and your trajectory and goals. That means, like, how large is your business? Where is it? Who are your competitors? How aggressive are they? Things like that. Because if you're small and you're not going to be noticed, there's very low chance of you being noticed by, the big players, then the risk of them coming after you is lower. I'm not going to say it's low, but it's lower. And it's important to recognize that as you grow, though, so does the risk. Okay, so that's it for patents. We're going to move on to trade secrets. This is going to be a pretty brief discussion, but these are potentially very valuable to your business. So the basics: a trade secret is any valuable commercial information that provides a business advantage over competitors who don't have that information. So very common examples are your customer contact list, maybe your in-house formulas or recipes for making whatever products you make. Maybe it's technical knowledge or know-how around these products or services. It's anything that you keep secret that you use in your business. What's very important, it's easy to obtain trade secret protection, but it's hard to maintain trade secret protection. So right off the bat, there is no need to apply for trade secret protection. There is no legal or government cost involved in it. It's only administrative costs, because what you need to do is you have to keep it a secret. And that sounds pretty obvious, but the way you do that is you have to take what are known as reasonable steps to keep that information a secret. So the most common examples of reasonable steps is that you mark your information, your trade secret information, as confidential and or proprietary. So you have that in either the header or the footer of whatever document it is. You also, if you can, restrict access to the information. So for instance, only those who need to know the information should have the password to access that information. And when you are interacting with others outside the company, you should always use NDAs or CDAs, non-disclosure or confidentiality agreements. They're very similar. They're basically synonymous before you share the information. And I know sometimes it's hard to get somebody else to sign one of these, but it's still an important thing to try to do. And if you can't get somebody to sign an NDA before you share information, then just be very careful about what you share and make sure that you're not sharing anything that's protected by trade secret. And here I have a little anecdote about extreme steps, so that KFC's 11 herbs and spices recipe is one of the best known trade secrets. And one of the reasons it is because of all these separate steps that KFC has taken to make sure that it remains a secret. And I'm not going to go through them. You can read through them because you're getting a copy of these slides, but to save time, it's actually very interesting and it's fun to read. So what do you need to know about trade secrets? Once the information stops being a secret, there's no more protection. There's no longer a trade secret, and you lose your trade secret protection, which is why I said before, maintaining trade secret protection is probably the hardest part of, working with trade secrets. And this also means you have to take those steps to treat the information as trade secret. Anything that you can think of, like I listed common examples earlier, but anything you can think of that's going to keep that information more of a secret and more internal to your company, take those steps, do that. And that's also where the administrative cost comes in, because this is something you have to do. This is your time and effort as a small business owner to take these steps. And it's also important to recognize that trade secret protection and patent protection are pretty much polar opposites. So a trade secret has to be secret, by definition. But in order to obtain a patent, when you're describing your invention, you have to tell the world exactly what you're doing with your invention and how to make it, how to use it, and why it's being used, all of that. So it's kind of a balance between like keeping it secret and telling the world. So usually they're opposites, and there are some exceptions which we will touch on briefly later, but for the most part, it's important to consider. So next, trademarks. This is very important for small businesses. We're going to start kind of on the federal trademark side, which is what a lot of people have heard of and recognize the most when people mention trademarks. Basically, a trademark, it tells a customer or a consumer who the source of certain goods or services are. So for instance, you're driving down the highway and you see the Golden Arches, you know that there's a McDonald's, and you know that they provide burgers and fries and other fast food. And that's exactly what a trademark does. But it's important to use your trademark properly. And what that means is that the trademark cannot be used as the name of the good or service itself, right? And here's a very easy test to make sure that you're using your trademarks properly. If you recite out loud, whatever the trademark is, brand, and then your goods and services, whatever they are. And that's how it should always read. And the reason this is really important is because if it's used improperly, it leads to a loss of trademark rights, which is known as genericide, and because it becomes generic for the goods or services that you're trying to protect. And examples of this are aspirin. So Bayer, back in the early 1900s, had trademark rights to aspirin, but over the course of time, with doctors prescribing aspirins instead of aspirin brand pain reliever, eventually became generic. And now everybody has an aspirin, including Bayer. Some other examples are dry ice, linoleum, and even heroin. These were all actual trademarks, but they have since become generic. There's no longer any trademark rights in these terms. So when you're thinking about trademarks, whether you have one now or you are considering a new one or actually coming up with one, you want to think about the strength of your mark, which is known. And real quick, I say trademark or mark, those two words are interchangeable. So please don't get thrown off by that. A trademark is a mark and so on. But inherent strength is basically the ability of your trademark to distinguish your goods and services from the goods and services of competitors, from others. And there's a sliding scale of strength. And I have it color coded. I have some examples, like for instance, tables is not a trademark. It's just generic. It's the good itself. It's the product itself. And then on the other end, you've got Apple for computers, because it's an arbitrary word. It's a real word, but it has nothing to do with computers. And then Kodak it's a coined term. It was made up. So you always want to aim for green, because anything less, you're going to have issues with the USPTO. Because, you know, in the last bullet, the USPTO will never register trademarks that are red, that are generic. They will, in certain, you know, minor circumstances, they'll allow orange or descriptive marks to be registered. Like for instance, Windows now has a trademark registration on its Windows software. Originally, it did not. So common types in the US. So we discussed federal. That's the one many know about and recognize. This you have to apply for to the USPTO. It gets examined by a trademark attorney at the USPTO. If it passes examination, it's published for opposition. And we're going to talk about that a little bit later too. But it's published so that your competitors can, if there are any competitors or others who may think that they'll be injured by your trademark, they can try to stop you. And if your trademark application passes that process, then eventually it becomes a trademark registration. Only at that point can you use that circle R symbol. If you don't have a trademark registration, you're not allowed to use that symbol. Instead, you have to use the TM, which we'll get to. And federal trademarks generally are much stronger than common law trademarks because, number one, they protect across, you know, all 50 states and, you know, the commonwealths of the US. They also provide some other additional protections and features in court, and that's getting into too much detail. But the downside of a federal trademark is that you have to use it in what is known as interstate commerce. So that means your trademark or your goods or services has to cross state lines. So oftentimes this is a pretty low bar and very easy to meet, because if you're advertising your goods online, that's likely reaching people across the country. And oftentimes that'll be enough to show use in the interstate commerce. Now, on the flip side, there are what are known as common law trademarks. This is a less well-known type of mark, but this is probably consists of the vast majority of trademarks. There's no application required. You gain common law trademark rights just by using your trademark properly. That's all it takes. The downsides, though, are that you can only use the trademark symbol, the TM, in the upper right-hand corner, and your trademark protection extends only to the areas in which you're using the mark. So if you're only using a mark and doing business in New York, New Jersey, and Pennsylvania, you won't be able to protect, use your common law trademark to protect the potential infringer in, say, California. So we're going to discuss strategy between these two later on, but that's some of the basics to recognize there. So
question. So
okay.
in essence, you can use the TM sign on anything as long as it's abiding by the common law.
Right. As long as you are using it as a trademark, and which means that you're trying to use it to indicate that you are the company or person who's providing that good or service, you can use the TM without penalty.
Got it.
So basically anything can be a trademark as long as it indicates the source. So it indicates you, the company, or the provider of the goods and services. You know, most common are words and or designs or logos, things like that, but there are less common trademarks. And I've listed some of them down there. And it's actually kind of interesting because there's smell, there's color, there's sound, there's touch. All of these have been registered with the US Patent and Trademark Office. Oops, what
did I see smell there? I'm sorry. Did I see smell?
You did. Play-Doh actually received a registration for the smell of its Play-Doh. You know, the unique smell that it has.
That it's very unique.
Yeah. Yeah. So they have a trademark registration on that. And any other, you know, toy company or somebody else who wants to make a dough like a Play-Doh like substance, they need to make sure that it doesn't smell like Play-Doh, or else they're going to get in trouble.
Wow, that's interesting.
So what can't be? This is probably more important than what can be, since basically anything can be. So what can't be a federal trademark? Anything that is, and this is in quotes because it's a legal term of art, anything that is confusingly similar to an earlier live trademark application or registration. Now, I say live because if you're applying for a federal trademark and there is a trademark that is spot on, but it's dead, like the applicant stopped using it, didn't pay the renewal, whatever it is, and it's no longer active, it can still, while it won't be an issue for you to get your federal trademark application through the patent office, it may still be an issue on the clearance side, because that mark can still be used in common law and you may infringe that mark, even though the federal application or registration is no longer active. So beyond that, there's also a federal trademark, or any trademark, cannot be descriptive or misdescriptive of the goods or services. So for instance, and you know, going back to the inherent strength of the trademark, everything that was in orange, that's known as descriptive or, you know, misdescriptive of the goods or services. And that's why I said usually it's not registrable, but there are ways to overcome it. And this also applies to geographical region. So for instance, you know, if you have Persian rugs for rugs, that's going to be descriptive. If it comes from, you know, Iran or that area, or misdescriptive if it comes from, you know, New Jersey. So here's another example of Florida oranges coming from Florida or not. There are ways to overcome these types of refusals, and that would be outside the scope of this presentation. Just know that you're not dead in the water if you get one of these. And I also have listed, but in strike through, anything that's immoral, scandalous, or disparaging. So this used to be part of the Trademark Act, and it was recently ruled unconstitutional by the US Supreme Court. It was done so through the Washington Redskins case, the football team. You guys remember all of that several years ago. So that's why I just want to, you know, cross that out. So you can have as many curse words or pornography or what have you with your trademarks if you want. Business-wise, probably not the best idea, but you can. So moving on to copyright. So this may be probably some of the most important information for you as a small business owner. So the basics are a copyright will cover, and this is a quote, this is straight from the statute, any original work of authorship that's fixed in a tangible medium of expression. And we're going to go through each of these underlined portions because they're all very important. And it's also, you need to know that the work has to have a minimal degree of creativity. So original here is different than original in the patent sense, where it needs to be brand new altogether. Here, it just means original to you as the author. So two separate people, two separate authors can, or artists can come up with the same exact work. It can be identical, and they might not infringe each other's copyrights. So long as, you know, it wasn't copied. The fixed and intangible medium part we'll get to a little bit later, as well as the degree of creativity. So, you know, very common examples of this are literary, dramatic, musical, and artistic works. So paintings, photographs, novels. To an extent, computer software, architecture, and other creative expressions that also serve a utilitarian function can be protected with copyrights, but it's a thin line, because usually useful features, utilitarian features, that's what's protected by a patent. So they're separate there, and you can't turn a patent into a copyright or vice versa. So here's an example, and what I was saying just explained in more detail. So a copyright does not protect facts or ideas. That's what the patent does. So for instance, a recipe is an idea. It's just a list of ingredients and directions for combining those ingredients. So that cannot be copyrighted, the recipe itself. But a copyright may protect the way that facts or ideas are organized or expressed. Like, for instance, a cookbook can be copyrightable if the author has creatively arranged or described the recipes. You know, if there's some added flavor that the author has introduced into the recipe, well, that, and I mean flavor as in just wording, not actual, you know, ingredients. Right. That can be protected by a copyright. So it's also the same thing with computer software. So the function that the computer program performs can't be protected with a copyright. It may be protected by a patent, but the way that the code is written, to the extent that it's not necessary to the function of the computer program, that can be protected with a copyright. So often for computer software, that can be protected by both, may be protected by copyright, by both copyrights and patents. So what is the copyright though? It's known as the bundle of rights because it is a number of rights that you can have, and they're separable from each other, and they can be infringed separately, licensed separately, anything you want to do with them, it can be split up. So when you have a copyrighted work, that protection allows you to stop others from reproducing the work, preparing derivative works, which is, you know, making a sequel or an adaptation, you can stop them. Distributing copies of the work to the public, so selling it, performing it, or displaying it. So for instance, if it is a photograph or a painting, somebody who's copied it can't, you know, show it somewhere. You can stop them from doing that.
You have to find them first, right?
Yeah, that's
Sometimes
one that
you won't find
copyright. So obtaining copyright protection is very, very easy. You gain copyright protection to a creative work as soon as it is fixed in a tangible medium. And now we have that again. What that means is it needs to be reproducible somehow. So for instance, if your creative work is a song, then once it's recorded, it is fixed in an intangible medium. Or if you've written down the notes into the scales or the bars, that is also a tangible medium and it's fixed there. So you have a copyright in that too. For videos, it will be as soon as it's filmed. and you kind of get the picture. It can't just be an idea in your head. It needs to be put down into paper or into recording or whatever it is. Now, you don't need an application or a registration for copyright protection, but you will need a copyright registration, which means you need to file a copyright application to the Copyright Office, which is separate from the USPTO. And you have to apply for a copyright on the work before you can enforce your copyright in court. Generally, how this works is that you have copyrights, nobody infringes them, hopefully. To the extent they do, you can license the copyrights. But if there is an issue down the road and you need, and there's no amicable resolution to this issue and it goes to court, well, then you need a copyright registration on that work before you can go to court. Now, usually the person, the author who creates the work, who fixes it in a tangible medium, automatically owns the copyright to it. But there are exceptions. For instance, works made for hire. And this is extremely important. So it gets its entire page. Now, work made for hire is where an entity that hires the creator or author of a work will own the copyright. I just said that. There are two ways to make this happen, because generally, again, the person who actually authors the work is the one who's considered the copyright owner. This happens if you're an employee of a company and you do this during your normal employment. But the other is more, it comes up more often and is probably more applicable to all of you. So this is the one to watch out for. Number two is if a work is especially ordered or commissioned, and if the parties expressly agree in a signed written document, so any contract or agreement, anything, that the work is intended to be treated as a work made for hire or something along those lines. Now, these words must be in the agreement. Otherwise, the author, the person who actually created the work, is going to own the copyright to it. This only applies to certain work, so do your research, but it's always good to watch for work made for hire language and contracts or in any of your dealings. So again, always watch for it. This is extremely important if you are a designer, a developer, content creator, anything along those lines where you create artistic works and you sell them to others, you're commissioned to do that. Or if you are a business that needs to hire or use one. So if you're a business and you need a website created, you're going to need to be careful of the work made for hire language in your contract, because you are going to want to own the copyright rights to everything. So in general, as small business owners or just as owners of any sort of business, you want to own all of your IP rights. So it's very important to make sure, to the extent you can, that you do own your rights.
Awesome. So you sort of answered it already. You can copyright a website design.
Mm-hmm.
Awesome. All right.
But it would also be more than just the design too. It could be the underlying code, the HTML, whatever it is that's created the website, as well as, any design elements or aspects that are on the website itself. So
wow,
there's a lot of copyrightable stuff in websites.
Yeah, that's super important to know, because as you know, it's super easy to just copy code and paste it into another website. Yeah. So, and competitors can do that very easily. So it's good to know that you're protected for that.
Yeah, that would be an unauthorized use of your copyright.
Right.
So here is an exception. It's called fair use. And it allows, it's a doctrine in copyright law that allows for certain unauthorized uses of another's copyrighted work without getting their permission first. But it's a very fact-specific doctrine. Here are the factors that, courts will weigh when deciding whether a use is fair or not, but you guys can read through this when you have a chance. So moving on to agreements, I mentioned this generally earlier. I think it deserves its own section, although it's kind of a little sparse right now, but agreements or contracts, same thing. In general, with today's uncertainty, you really want to make sure that your contracts are really up to par. They're very strong and protect you. They accomplish what you need accomplished, because contracts really are your first line of defense. Before IP or anything else, contracts are probably the most important place to spend your legal budget if you have it, if it's limited. So yes, agreements, and I can't stress it enough, they are very important. So because they're so important, they need to be tailored. Each one needs to be tailored to your business, to your market, the particular transaction, and the purpose of that transaction. The reason I say this is that stock or template agreements, which people use often, they can be used as a starting point, but they are just not drafted to cover every situation or important issue to your business or to whatever the transaction is. So if you do use a stock or template agreement, make sure that you go through the entire thing, think about all of the words in there, throw out what's not relevant, add things that are relevant to you and your business, and then use that. And of course, it's recommended to talk to an attorney who does do this work in your area, to make sure that all the T's are crossed and I's are dotted. But moving on, in general, and probably more key to this presentation, is what are known as ownership of IP or assignment clauses or language in agreements. So this is somewhat similar to work made for hire language, because what it does is it transfers ownership of the IP right, whatever it is, a patent, trademark, copyright, to somebody else. So these are important whenever something's being made or created or developed, or even if there's a chance of it happening. Like there are service agreements or even employment agreements where assignment language is very important, terms and conditions, privacy policies. If you've gone through some companies' terms and conditions, like I think maybe Twitter or Facebook, oftentimes they'll have some language saying that you assign or at least give them a license to use whatever content you post. So that's important to recognize. It may not be avoidable, but it's something to keep in mind. And also very important wherever there is confidential or proprietary information being used or exchanged or anything like that, because oftentimes protectable IP can arise from those sorts of situations, and you want to make sure that you're protected. And of course, use or avoid work made for hire language as applicable, depending on what side you are in the negotiation or in the transaction. So
sorry, quick question. So I know that it's probably better to speak to a lawyer, but do you recommend anywhere to get templates?
Oh, no. I know of Rocket Lawyer. I've never used them or any of the other document template sites. So right. I don't have any recommendations for who's good or not.
Gotcha. So stick to a lawyer.
Yeah, I mean, and honestly, with this, and especially considering the times and the uncertainty and the struggle we've all been going through, one of the best things you can do may be to get a stock or template agreement, write it up as best you can, and then send it to attorney. Because the
Right.
more you do might be the less that the attorney has to do, so the less you pay for it.
Right. Yeah, good strategy.
Okay, so here are just some common agreements where IP comes up pretty often. Your NDAs, CDAs, this, I mentioned earlier. These are important to protect the confidentiality of your information, as well as to keep your trade secret protection available. You should always sign these prior to disclosure of any information. That's kind of common sense, but sometimes it doesn't happen. So try to keep that in mind. Also, licensing agreements. These are very important for IP. This is one of the ways, IP is monetized. And there's two types. There's in-licensing and out-licensing. So in-licensing is when you need to use somebody else's IP, you license in the right to do so. For instance, let's go back to copyrights. If you want to create a sequel to, a best-selling book or movie, then you would most likely license in the right to create a derivative work from the owner of that book or movie's copyright. Now, out-licensing is the other direction. This is when you own the IP and you license the right to use it to others, usually for some form of payment. This is a great way to monetize your IP. In addition to licensing, there's also assignment clauses. You can sell your IP too. That's not quite listed here, but in most sale agreements, there'll be some sort of, the ownership of IP language that I mentioned earlier, assignment language. And there's also, IP is commonly a thing in development or developer agreements, and who owns the IP when something is being created or developed is going to be a key issue or question with these types of agreements. And, for instance, that last bullet is repeating what we've discussed before. So now on to the good stuff. Topic 2, practical tips and considerations. So here we're going to discuss, obtaining IP protection, the various kinds, good ways to do it, bad ways to do it. And also number 2, which I mentioned before, may be more important than number 1, is avoiding or reducing your risk of infringing somebody else's IP. We're also going to talk about what you can do yourself to save costs, as well as how to do it, and instances where you really should find an expert or an attorney to help you, because it's just not worth trying to do it yourself. And we're also going to, this is my little added bit, kind of, it doesn't have anything to do with IP really, but tips for finding and working with an attorney to maximize value, because a lot of people, and I think a lot of the small businesses, aren't really used to working with attorneys or finding attorneys, and I think this will be helpful too. So in general, doing it yourself, you want to research before taking any action, common sense. The USPTO and the Copyright Office have amazing online resources. For both patents and trademarks, the USPTO has like step-by-step directions on what to do and how to do it. And they'll even provide some recommendations for you as well. Like for instance, they'll say, don't just file a trademark, conduct a trademark search, which we'll talk about soon, to make sure to improve your chances of actually getting a registration on your mark. So these are very valuable resources, and certainly if you're going to do it yourself, start there. If you can't find a question answered, or you have an issue that's not discussed in either of those websites or those 3 websites, You can also look to the reputable lawyer or law firm posts and articles because they'll often go a little more in depth than the patent, trademark, or copyright office might. Just make sure they're reputable firms or lawyers, and also try to check the date that the article was written or posted, because again, the law changes all the time, and there may be an article that's no longer current and is actually, contrary to current law. You want to try to avoid legal tech companies and other non-lawyer websites and their articles. The information that you find there can be wrong or dangerously incomplete, and their services can be hit or miss. Sometimes it works, oftentimes it does not. And in general, if you're losing more than you're gaining by doing it yourself, you're doing too much. And that's something to keep in mind for all of this. So we're going to start with patents and trade secrets, basically because they are quite related. So obtaining a patent, right here in the title, it may not be worth it. We've discussed this before. They're very expensive. They also take a long time before they can provide any useful protection. And that's only if they actually get issued by the patent office, which may or may not happen. That's a risk. So if you have a limited budget, you want to just kind of forego this. Here are some of the costs and other things to consider if you are interested in patent protection. What's the potential value of having a patent, and what are your chances of actually getting a patent? And if you do get a patent, how strong would that patent actually be? And the way you answer these questions are various due diligence efforts, such as patentability searches, which we'll discuss in a second. So patent or trade secret. The important thing to cover here is you want to determine first which protection you want to use. Here's the pros and cons of patents, the pros and cons of trade secrets. It's important to note that trade secrets are a bit more adaptable than patent protection is. So if you need to pivot or in some way be resilient to the changing times, maybe considering keeping your information as a trade secret is a better decision than trying to apply for a patent. And again, like I mentioned, it may be possible to have both patent and trade secret protection on the same thing, but you would have to consult an experienced patent attorney first. So infringement, patent infringement. This is really very important for you. The way you find this out, the due diligence effort, is called either a freedom to operate, FTO, or a clearance search. You look, basically what happens is that you or somebody goes out, sees what patents are active, their claims, and whether your product or service might infringe that patent. Now, it's important to note that this is a legal opinion, which means a patent attorney needs to provide it for an FTO opinion on the patent side. This is not something you do yourself. But also, before deciding to do this, again, remember your commercial context. The search should be related to your market and where you are in the market, your actual potential revenue from the product or process that may be an issue. And again, the smaller you are, the less chance somebody else is going to come after you. As you grow, so is your risk. So if you're working with a limited budget, this may be something that you can forego until later. But in the situation where you have an exit strategy that is being acquired by a larger company, FTO risks are very important for those larger companies because they have a lot more money, they have much deeper pockets, and a much bigger bullseye on their back. So they are going to really be concerned with any FTO risks that you present.
Mike, I hate to rush you, but we have 1 minute left. Are you able to wrap up a little bit? But we'll go over some questions and answers a little 5 minutes over if we can.
Okay, I will go through this very quickly. A lot of it's written down. Here's what you can do yourself if you want a patent, if you want to avoid infringement. There's plenty of places to search online. Again, understand your markets, trademarks. These are the questions you want to ask yourself, your company, before you decide to file for a federal trademark application. Your due diligence is similar to the patent side. You conduct a search, you see if there are other marks being used by competitors. And it's important here to also Google, because that will pick up, or that may pick up common law uses, which won't be in the USPTO's database, which would still be an issue for you. Here's timing of when to conduct a trademark search, and you can read through that. Here's what you can do yourself, some cost estimates. Again, this is how to do a trademark search. Really use the search help resource. And that should help you a lot. Here are just copyright tips, because honestly, as an attorney, there's very little we do with copyrights until there's an issue. Like for instance, until there's a litigation or a conflict with some kind of license. So this is more so on your end. Just read through this and keep this in mind. Finding and working with an attorney. The one thing to take away from this, well, two things. One, if it's a patent issue, you need a patent attorney. A patent attorney has a science background, and they have taken what is known as the patent bar, which is different than a state bar, which makes somebody an attorney, that makes them a patent attorney. And their background or experience should match your technology. For the other forms of IP, any IP attorney with experience will work, but you want to try to vet your attorney first. So doing that, the best way to do it is to start with your network, the NJSBDC, friends, family, whoever knows attorneys. You may get bounced around a lot and referred to various different attorneys, but eventually you should land on somebody who can help you. Then working with an attorney to maximize value, it's all kind of straightforward. You want to discuss everything up front. You want to get costs, all the details, pros, cons, everything. And with the cost, once you get the bill or invoice at the end, you want to check it and make sure it makes sense. If cost is an issue, do consider asking that attorney or law firm whether they do what are known as alternative fee arrangements, which really can be absolutely anything, as long as the attorney is okay with it. And then also remember that attorney's time is their livelihood. So if they're working on your case or your matter, they're not working on somebody else's. So there's only so much that they can do. And I'm going to go very quickly through this because this is really the meat of it. And so here's how to identify your IP and protect it. So step one, and this is all kind of outlined here, so you can go through this later, but you want to find your main revenue driver, what really makes you the most money, and find out how you're using IP to along with that revenue driver. Right, here are various questions to ask. Then you go through the various forms of IP for that main revenue driver and the way it uses IP. And here are the questions to ask for each of these. So what's the potential value to the business? What are your chances of getting it? What's the cost of obtaining and maintaining it? Because once you have a patent or a trademark, you're going to have to pay maintenance fees or renewal fees. So there's long-term costs involved too. And also enforcing it. Like if you have a patent or a trademark, somebody infringes it, or even a copyright, for that matter, and somebody infringes it, what are you going to do about it? It all costs money. So you need to keep that in mind too. And also consider if there are any other downsides of having that IP. So for instance, like the distinction between the patent, applying for a patent and keeping information trade secret, that might be something to consider here. And once you've done this analysis, you can make an informed decision about which IP protection is best for your business and then pursue that first. But that's not it. Step 3, you want to layer IP protection, because one picket doesn't make a fence, and all of the forms of IP protect different aspects of intellectual property. And so for instance, here are some examples where if quality is what makes you unique, here are different ways to protect it. And you can go through this yourself later. The main thing here is step 4, create a comprehensive IP strategy, is what I call it. It's basically your business's overall approach to IP, all IP, whether it's valuable to you or not. And it includes all of your due diligence efforts, and it forms the basis for your business's use and protection of the acquired IP. So the way you do this is essentially just repeating steps 1 through 3 for every other aspect of your business. And it may not even need to be a revenue driver. It may just be something that's valuable to you internally. And just go through the analysis, see whether it's worth protecting and how to protect it, all of that. And very important part of the comprehensive IP strategy is that there's going to be a point where the costs and downsides of getting IP protection is going to outweigh the value of actually having that IP. Now, that doesn't mean that you stop right there and don't use that IP anymore. You can still use the IP and just not take any steps to protect it, but just make sure that there is a low risk of you using that IP. Like, that's very important. So as long as you're not going to infringe somebody else, you can use whatever IP you want without protection. And closing tips. I don't need to read these. We can just jump to the Q&A.
Awesome. We could leave that up. I'll have you leave that up there while we get into some quick. We'll do a little bit of rapid fire here.
Okay. Bring it on.
All right. So I see here. What if Adrian asks, what if your trademark is a combination of red and another color, not just red?
Right. So that's going to be a design mark. So it can be protectable as a trademark, but you need to describe that. If you're going to file a federal trademark application on that, you're going to need to describe to the USPTO exactly what the mark consists of, the design of it. So you're going to have to say, my mark is a combination of the color red plus one of these other colors, or you may even say a non-red color, or something like that. But that can be a trademark for sure.
Awesome. Awesome. Megan asks, if you're creating, say, a series of classes, can you copyright the series as a whole, or do you need to copyright each session independently?
That is a good question. So again, you will have copyright protection in the creative aspects of your classes as well as the series as a whole. You won't have copyright protection in the actual factual, like, information, utilitarian information. But you don't need to register or apply for a registration until you need to litigate the copyright, or you see some kind of issue arising and you want to get ahead of it. But I would recommend, actually, no, I take that back. I don't recommend it. It may be prudent to register everything if you get into that situation, the series as a whole, as well as each session independently. Also, just want to follow that up because we talked about costs for the other things, and there's some costs included in the PowerPoint for trademarks, but for copyrights, it's very, very easy to file for a copyright registration application. And I tell everybody to do it themselves. I always say, like, I'll be here if you have questions, but really, you guys, it's very easy. And the fee for it is very low compared to the other, compared to patents or trademarks. I think it's about $55 now per application. And there may be a way to file all the series plus each individual one as one application. But that would require some additional research. But what I'm saying is that it shouldn't be cost prohibitive to cover everything.
Awesome. So we're a little bit over. So I'm gonna have you, let's drop your email. Can people contact you?
Sure.
Awesome.
Sure.
So what email can people reach out if they have any more questions?
Right now, I'm kind of in the process of setting up a business email, but right now the best one would just be mikemaliar@gmail.com. I have separate, folders for work emails and personal, so that's probably the best one to use right now because other emails may change in the future.
Awesome. So how can you spell that out?
Yeah, so MIKE and then no space, MALYAR@gmail.com.
All right. So everyone, I'm dropping his email into the chat. Feel free to reach out for any more questions regarding patents, trademarks, copyright, everything IP. So to close out this session, I'm just going to let you, if you could just stop sharing the screen there so I could share mine here.
Will do. There we go.
All right. So that was it for the Q&A. Thank you everyone for coming. Keep in mind that we are the New Jersey Small Business Development Centers. We have a center covering anywhere where you are, and we help small businesses with zero cost expert business counseling, low to no cost training and resources, and we're powered by the SBA and several other partners. So to get started and get counseling, you can go to that link on the bottom there. That's njsbdc.com/request-counseling. You have to have the dash in between the request and counseling or else it won't work. But I'll drop it into the chat here. And everyone can go on there. Request for counseling, again, it's no cost. And make sure to follow us on social. So if you have a Facebook, Instagram, LinkedIn, we're planning on doing some special things on there. So make sure you're following us specifically on social media at NJSBDC, or we might be as at NJSBDC HQ for headquarters. And yeah, that's pretty much it. Let me see if there's any last questions here. Nope. All right. So thank you everyone for coming. Thank you, Mike.
Yeah, thank you. And you're all welcome. It was a pleasure. I love talking about this stuff, and feel free to reach out or however the process works. Like, I'm happy to talk about IP. I can do it for hours.
Awesome. Can we copyright this?
Yeah.
All right. So it's copyrighted. No one can copy this presentation.
You got it. Except you may not want to use it in a few years because it may have changed.
Right. Awesome. So thank you everyone for coming, and make sure to stay tuned for the one that's coming up next week. NJ Thrives Thursdays, same place, same time. All right. See you everyone.
Take care.